Similarly, the affidavit of another Walmart employee who averred that she generally passed by the subject display 9 times per day failed to state with any particularity the last time she had been in the general vicinity of the general display prior to the accident. Moreover, her affidavit does not demonstrate that she actually inspected or even looked at the subject display on the date of the accident. Compare Collins versus Mayfair Supermarkets Incorporated, 13, Appellate Division 3rd, 330. Accordingly, the Supreme Court properly denied that branch of Walmart's cross summary judgment, dismissing the complaint insofar as asserted against it. Walmart also challenges the granting of that branch of Coca-Cola's motion, which was for summary judgment, dismissing Walmart's cross-claim against Coca-Cola for contractual indemnification, and the denial of that branch of its cross motion, which was for summary judgment on that cross-claim. The right to contractual indemnification depends upon the specific language of the contract. When a party is under an alleged duty to indemnify, a contract assuming that obligation must be strictly construed to avoid reading into it a duty which the parties did not intend to be assumed. Further, contracts will not be construed to indemnify a person against his own negligence because unless such intention is expressed in unequivocal terms. That is not to say that the indemnity clause must contain express language referring to the negligence of the defendants or indemnity, but merely that the intention to indemnify can be clearly implied from the language and purposes of the entire agreement and the surrounding facts and circumstances. Margolin versus Life Insurance. When the intent is clear, an indemnification agreement will be enforced, even if it provides indemnity for one's own or a third party's negligence. Here, the indemnification clause in the vendor agreement entered into between Coca-Cola and Walmart provides as follows. Vendor Coca-Cola shall protect, defend, hold harmless, and indemnify purchaser Walmart from and against any and all claims, actions, liabilities, losses, costs, and expenses, including reasonable attorney's fees and costs, even if such claims are groundless, fraudulent, or false, arising out of any factual or alleged infringement of any patent, trademark, trade dress, or copyright by any merchandise sold to the purchaser hereunder, or arising out of any actual or alleged death of or injury to any person, damage to any property, or any other damage or loss by whomsoever suffered, resulting or claimed to result in whole or in part from any actual or alleged defect in such merchandise, whether latent or patent, including actual or alleged improper construction or design of said merchandise or failure of said merchandise to comply with specifications or with any express or implied warranties of vendor, or arising out of any actual or alleged violation of said merchandise or the manufacturer's possession or use or sale of any law, statute, or ordinance of any governmental, administrative order, rule, or regulation arising out of vendor's installation of merchandise covered by this agreement. The duties and obligations of vendor created hereby shall not be affected or limited in any way by purchaser's extension of express or implied warranties to its customers, except to the extent that any such warranties extend beyond the scope of vendor's warranties, express or implied, to the purchaser. It is further agreed that all duties and obligations of vendor set forth in this paragraph shall extend in full force and effect to the pallets or other transport or display provided by or at the direction of the vendor. Contrary to the Supreme Court's determination, the final sentence in the indemnification clause obligates Coca-Cola to indemnify Walmart for personal injuries allegedly resulting from, as the plaintiff sets forth in her amended complaint, the negligent display of the subject Coca-Cola products. Moreover, the indemnification clause was not limited to claims arising out of those categories specifically set forth in the previous portion of the clause, namely infringement, products liability, and violations of law or regulations. Thus, the indemnification clause was applicable to the subject matter.